Hello and welcome viewers, you're watching our brand new show In Depth with your host Kriti Mishra, a platform where we break the most complex issues of the world and our country in just 5 simple questions and their 5 simple answers and help you understand how these issues matter to you. The Places of Worship Special Provisions Act of 1991 is often seen in the news in relation to the Ram Mandir and the Krishna temple at Mathura and the Kashi Vishwanath Gyanvapi Mosque issue. So let's analyze the Places of Worship Act today. So why was the 1991 law enacted? This law was enacted by Parliament under the P.V. Narasimha Rao government in 1991 in the backdrop of Ram Mandir agitation. It is described as an act to prohibit conversion of any place of worship and to provide for the maintenance of the religious character of any place of worship as it existed on 15th day of August 1947. It was intended to preempt new claims by any group about the past status of any place of worship and attempts to reclaim the structures or the land on which they stood. It was hoped then that the legislation would help the preservation of communal harmony in the long run. So how did the opposition react to the law then? Well, the Bharatiya Janata Party registered its strong opposition to the enactment. The BJP leadership denounced the bill as another example of the pseudo-secularism being practiced in the country. It saw in it an intention to appease the minorities. In Parliament, the BJP also questioned Parliament's legislative competence to enact the law as it pertained to places of pilgrimages or burial grounds which were under the state list. However, the Union government said it could make use of its residuary power under Entry 97 of the Union list to enact this law. So what are the main provisions under the Act? Well, Section 3. This section of the Act bars the conversion in full or in part of a place of worship of any religious denomination into a place of worship of a different religious denomination or even a different segment of the same religious denomination. Section 4.1. It declares that the religious character of a place of worship shall continue to be the same as it existed on 15th of August 1947. Section 4.2. It says any suit or legal proceeding with respect to the conversion of the religious character of any place of worship existing on 15th of August 1947 pending before any court shall abate and no fresh suit or legal proceedings shall be instituted. So what are the exceptions? Well, ancient and historical monuments and archaeological sites and remains that are covered by the Ancient Monuments and Archaeological Sites and Remains Act 1958. A suit that has been finally settled or disposed of, or any other dispute that has been settled by the parties or conversion of any place that took place by quiescence before the Act commenced. The Act also does not apply to the place of worship commonly referred to as Ram Janmabhoomi. This law will have an overriding effect over any other law in force. And what was the Supreme Court's view? Well, in its verdict, the Supreme Court commended the enactment as one that preserved the constitutional value of secularism by not permitting the status of a place of worship to be changed. The state has, by enacting the law, enforced a constitutional commitment and operationalized its constitutional obligations to uphold the equality of all religions and secularism, which is part of the basic feature of the Constitution. It said the Places of Worship Act imposes a non-derogable obligation towards enforcing our commitment to secularism. The court observed that non-retrogression is a foundational feature of the fundamental constitutional principles, of which secularism is a core component. Well, viewers, that's all I could pack for you in this edition. Thanks for watching and stay tuned to Sansad TV. Goodbye for now.